my research investigates how the interim protection of Informal Land Rights Act can aid in pursuing environmental justice for communities impacted by proposed mining activities. The research considers how IPILRA was invoked in the cases of Baleni and Maledu to pursue environmental justice in South Africa. Due to deep-seated poverty and income disparity and the lasting effects of apartheid, the consequences of negative environmental impacts are not distributed evenly across South African society. One of the numerous ways in which this has manifested and continues to do so is the siting of hazardous land uses near poor Black communities. One example of this is mining. Not only do mining activities displace the actual homes of individuals, they can completely disrupt communities, both economically and culturally. The disruption caused to these communities has an incredibly negative effect on health, housing, lifestyle, as well as the surrounding environment, which is relied on for food, water supply, and oftentimes an income from any surplus food. The land is used for grazing for livestock, as well as for the cultivation of crops. Family graves, which have been present for centuries, are also lost because of mining activities, severely affecting family rituals and spiritual rituals. Environmental justice in South Africa is focused on social transformation, redressing the injustices of the past and providing a more equal distribution of natural resources. The environmental justice approach aims to challenge the abuse of power, which has resulted in the poor and vulnerable having to suffer the effects of environmental damage for the economic gain of others. Accordingly, it pursues the rectification of the unjust living conditions and biased distribution of environmental benefits and burdens in society, promoting equal value of all life irrespective of wealth and power. Finally, participation of previously disadvantaged communities in decision-making with regards to their environment and the land on which they live is integral to obtaining environmental justice. All South Africans should be afforded equal protection to their rights. And so there are just 4 important concepts to keep in mind during this presentation, and on which the judgments in the 2 cases I'll be referring to have relied. First of all, there's Section 24 of the Constitution, which states that everyone has the right to an environment that is not harmful to their health or well-being. And secondly, Section 25(6) of the Constitution, which states that a person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws or practices is entitled, to the extent provided by an Act of Parliament, either to tenure which is legally secure or to comparable redress. Then there's Section 211 of the Constitution, which recognizes customary law and requires the courts to apply it in cases where it is applicable. And finally, the National Environmental Management Act and its environmental impact assessment regulations, which provide for a structured public participation process before acquiring authorization for activities listed as having a harmful effect on the environment. So against the backdrop of the plight of communities affected by mining and the need for environmental justice in South Africa, this research will discuss the protection afforded by IPILRA to communities when mining is proposed and how this protection supplemented previously existing protection. The courts in Baleni versus Minister of Mineral Resources and Maledu versus Itereleng Mineral Resources questioned the level of consent necessary to acquire a mining right over land informally held by a community or through a customary land tenure. The provisions of IPILRA, as well as the Mineral and Petroleum Resources Development Act, are significant here. The Mineral and Petroleum Resources Development Act in Section 4 provides that a mining right is a limited real right, which entitles the holder of the right to enter the land to which the right relates, together with its employees, plant machinery or equipment, and undertake mining activities. Consent of the occupants of the land under the MPRDA is not expressly required. The protection afforded to these parties in terms of the MPRDA provides that the relevant occupants or landowner must be consulted prior to the mining right being granted by the Minister of Mineral Resources. Section 5A of the Amendment Act merely provides that at least 21 days written notice must be given. The Interim Protection of Informal Land Rights Act was initially temporary. It has, however, been repeatedly extended. IPILRA affords individuals and communities informal rights to land. It arguably pursues access to land as an aspect of environmental justice without insisting the Western notion of ownership. Section 2.1 of IPILRA provides that people may not be deprived of their informal rights to land unless their consent is obtained or the land is expropriated by the government and the appropriate compensation is paid. What is most significant about IPILRA is that this legislation has been interpreted to require the full and informed prior consent of informal land right holders before a mining right may be granted, as opposed to the mere consultation or notice required by the MPRDA. Additionally, Section 2.4 provides that for a community to dispose of communal land, the full and informed consent of the majority of right bearers present after sufficient notice and opportunity to be present has been afforded. It must be obtained before a community may dispose of their communal land. The protection afforded by IPILRA supplements the protection afforded to communities by the MPRDA, while the MPRDA regards the mere consultation or notice of the right holders as acceptable before mining rights to the land are granted. IPILRA affords informal right holders the opportunity to consent to propose mining activities or abstain from consenting if they wish not to be deprived of their land. The protection was highlighted by judicial interpretation and decision in the Baleni and Maledu cases. In the Baleni case, this case concerned a community who has been living on the Wild Coast in an area called Umgungundlovu for centuries. This area is home to 70 to 75 households called Imizi, made up of approximately 600 individuals. The applicants consist of 128 adults from 68 of these Imizi. Transworld Energy and Mineral Resources, an Australian mining company, wished to mine titanium and other minerals on or nearby the area which most of the applicants' households are located. This would include open-cast mining activities, wet separation plants, slimes dams and tailings dams, accommodation for employees, access roads, offices, power lines and stores, clearly affecting both the community and the environment to a large extent. The mining right had been granted by the government in 2008 with the consent of the local chief, but many community members were not in support of this. Violence thus broke out between the parties and amongst the community members, resulting in an 18-month moratorium being implemented by the Minister of Mineral Resources due to the social and political climate at Xolobeni. The case concerned whether the mining company or the community had the right to determine whether mining activities could commence. TEM relied on Section 5 of the MPRDA, which provides that a mining right is a limited real right which entitles the holder to enter the land to which the right relates and undertake mining activities for its own account. They argued that consent of the community under the MPRDA was not required, and that the relevant community or landowner need only be consulted prior to the mining right being granted by the minister, and that no community had the right to refuse consent. If not for the protection of IPILRA, the community in this case could legally have been deprived of their land, as they did consent. They were consulted, sorry. The applicants, however, argued that in terms of Section 2.1 of IPILRA, no person may be deprived of any informal right to land without his or her consent. It was held in this case that the MPRDA and IPILRA should be read together. The court held that the purposes of both acts can be read together as they were both enacted to redress the effects of apartheid. It further held that in order to protect customary communities' informal rights, which were not previously protected, the applicants had the right to decide what happens to their land. Additionally, as this land was regarded as communal, a communal decision had to be reached through a majority vote of the right holders present. The court in this case took the decision of the Maledu case into account. The Maledu case concerned the community of Itereleng, who was evicted from Wilgesveld Farm in the Northwest Province, that they had occupied for nearly 100 years. The applicants contested that the farm was purchased in 1919, but due to discriminatory laws, could not be transferred into the names of the purchasers. For this reason, the minister holds it in trust for the community. The farm was used to grow crops and hold livestock, and over the years, houses were erected for the community and the employees. Itereleng mineral resources and Pilanesberg platinum mines intended to use the land to mine platinum group metals and obtain the mining rights to do so. As in the Baleni case, the mining companies argued their rights through the MPRDA, while the community argued their rights in terms of IPILRA. The court held that it is necessary to interpret legislation in accordance with the spirit, purport, and objects of the Bill of Rights. It was held that IPILRA and the MPRDA must be read together and do not contradict one another. However, it must be added that IPILRA must serve its purpose of protecting customary land rights. Thus, the community in these cases were not deprived of their land without their consent. The court was able to use IPILRA to protect the informal rights of the communities, thus addressing injustices of the past relating to land and pursuing environmental justice for vulnerable individuals. Criticism does, however, remain regarding the interim nature of this protection. IPILRA is clearly effective as a tool to protect access to land and participation. However, the fact that IPILRA was initially temporary and has merely been repeatedly extended does make one question whether it really is good enough as a tool to protect access to land. This is due to the fact that its authority is dependent upon its extension. One may argue that a greater mechanism to achieving environmental justice in South Africa would be to either supplement the MPRDA to provide the protection that IPILRA provides, thus avoiding the need to extend IPILRA annually, as well as having to read the MPRDA and IPILRA together in court, or to make IPILRA final and binding legislation. Permanent protection needs to be afforded to communities, such as those in these two cases. It is therefore necessary for permanent protection to be afforded through the enactment of final legislation. Thank you.